Article 11 of the Civil Code provides that customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12 provides that a custom must be proved as a fact according to the rules of evidence. These are the two articles of the Civil Code that treat with customs. There are other provisions of the law which mention customs. Hindi ito masyadong tinatanong, kapatid. Maaaring sa kaklase mo lang na minalas at sa kanya pa pina-define. Maaaring itanong ito sa quiz, but it is not important enough to be asked during your midterms and definitely not in your final exams. Today, we're going to use these two articles to introduce you to the world of customs, a little of legal ethics, and a little on evidence. We will also look at Article 13 and how it's been superseded as the rule on the computation of legal periods. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. In the case of in re authority to continue use of firm name CSIP, the Supreme Court teaches us that a custom is a rule of conduct formed by repetition of acts uniformly observed as a social rule, legally binding, and obligatory. The Civil Code authorizes persons to use their names together as the names for their partnership. When an accountant opens an accounting firm, he can call it Pedro and Associates Accounting Firm. If Pedro later on becomes a lawyer and marries his law school sweetheart, they are free to open a law office and call it Pedro and Pepita Law Office. The law provides that partner may use none, one, some, or all of the names of the partners as the partnership name. If a person who is not a partner has his name included in the partnership name, the law makes that person liable as if he or she was a partner. This is Article 1815 of the Civil Code. In this case, kapatid, meron dalawang abogado na namatay. They belong to two different offices and the two law firms came to court to ask for permission for them to be allowed to use the names of dead partners, because the names of dead partners are the names with which they were known. Doon kasi sila sumikat at doon sila nakilala. Kung babaguhin bigla ang pangalan ay baka hindi na ganun katunog, kalutong at kabigatin ang pangalan. The Supreme Court ruled that it must be conceded that in the Philippines, no local custom permits or allows the continued use of a deceased or former partner's name in the firm names of law partnerships. Firm names under our custom identify the more active and or more senior members or partners of the law firm. A glimpse at the history of the firms of petitioners and of other law firms in the country would show how their firm names have evolved and changed from time to time as the composition of the partnership changed. As you can recall in our previous lessons, the dissenting opinion of a justice is often the basis for the abandonment of the rule. In case you have missed our previous lessons, I encourage you to go back and I'll have a link to that in the description down below. In this case, Justice Aquino dissented from the main opinion. Pinagpaguran naman ni na Attorney Sisip at Attorney Ozaita ang kanilang mga reputasyon. Hindi naman illegal na hindi ito pakinabangan ng mga iniwan nilang kasama. Justice Aquino points out that the law offices should be allowed to use the names of dead partners basta ba nakasulat na napatay na sila. About 8 or 9 years later, the Supreme Court came out with the Code of Professional Responsibility. It is the main law we have to study for legal ethics. It's very interesting to read kahit na wala ka pa sa law school dahil narito ang lahat ng mga dapat gawin, dapat sundin at dapat panghawakan mo, kapatid, kapag ikaw ay abogado na. I will leave a link to that in the description down below. In 1988, the Supreme Court gave us the Code of Professional Responsibility. Based on the dissent of Justice Aquino, we now have Canon 3, Rule 3.02 that provides the continued use of the name of a deceased partner is permissible provided that the firm name indicates in all its communications that said partner is deceased. As things now stand, a deceased law partner's name can still be used in the name of the law office, sa mga letterhead, sa mga business card, at sa signages sa labi ng kanilang opisina. All that the Supreme Court requires is that we put a small cross next to the name of the dead partner to let everyone know that he has passed away. In the same case, the Supreme Court points to us that there are two kinds of customs. A juridical custom is one that is legally binding and obligatory. It is not a written law, but it can be used to supplement a rule. Halimbawa ng juridical custom would be the practice of sending advance copies of pleadings and motions to the opposing counsel. Kung may gusto kang gawin, sabihin o pag-usapan bago ang isang hearing, common courtesy na sabihan mo na ang abogado sa kabila para mapag-aralan niya, mapaghandaan niya, at masabihan din niya ang kanyang kliyente. Once upon a time, katulad nung nangyari sa dissent ni Justice Aquino, juridical custom lang yan, but that has now been formalized into part of the rules of court. The second kind of custom is the social custom. These do not have the obligatory effect of laws. They cannot in any way supplement our laws. Article 12 points out that customs that are contrary to law cannot be tolerated. According to Attorney Rabuya, before a custom may acquire the force of suppletory rule, the custom must meet the following requisites. 1. Plurality of acts or various resolutions of a juridical question raised repeatedly in life. 2. Uniformity or identity of acts or various solutions to the juridical question. 3. General practice by the great mass of the social group. 4. Continued performance of these acts for a long period of time. 5. General conviction that the practice corresponds to a juridical necessity or that it is obligatory. 6. The practice must not be contrary to law, morals, or public order or public policy. Dadalawa lang ang tanong sa customs, kapatid. Yang requisites na yan at kung paano dapat patunayan ang isang custom. Article 13 provides that a custom must be proven as a fact. Courts cannot take judicial notice of a custom. It has to be proven through the rules of evidence. When the law provides that courts cannot take judicial notice of a fact, it means that judges and justices are not allowed to accept the fact as proven. Hindi yan given. Kailangan pa rin niyang patunayan. This brings me to the basics of evidence. Evidence is the means, sanctioned by the rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. That is the first rule on evidence. Just because something exists does not mean that something is true. Ang evidence, kapatid, ay proseso. Kung tinutukoy mo naman ang bangkay, ang fingerprints, ang patalim na ginamit, yan ang tinatawag na pieces of evidence. Kung may natagpo ang mga footprints na size 11 at mukhang Chuck Taylor ang swelas, it does not prove that the killer came to the house of the victim wearing the same shoes. Based on the rules of evidence, it only proves that someone wearing a pair of size 11 Chuck Taylor shoes was in the scene of the crime. In the same way, one single act is not a custom. Kailangan nating patunayan na paulit-ulit itong ginagawa ng higit na nakararaming tao sa loob ng mahabang panahon ng mga taong naniniwalang dapat nilang gawin ito at hindi naman ito labag sa anumang batas. According to Attorney Balane, customs are often used in torts. Noong unang panahon daw ay ang mga kalesa ay dapat may basket na ratan para hindi mahulog ang mga pasahero. Sa parehong paraan na tuwing umuulan, humihinto ang mga jeepney driver para ibaba ang maiksing plastic na trapal para hindi mabasa ang mga pasahero. Bonus na lang kung may mga maliliit na clip ang plastic para hindi liparin ng hangin. Kung sakaling may lola na nadulas sa loob ng jeep dahil walang trapal ang mga bintana o tamad si kuya driver, then this custom can be proved to show that the jeepney driver and the operator were negligent in the carriage of Lola, resulting to her injuries. I think that's it for customs, kapatid. Let's now go to the computation of legal periods. In our previous lessons, we talked about implied and express repeal of laws. In case you missed it, there's a link to that in the description down below. Now, kapatid, let's discuss how periods of time are computed under our laws. Article 13 of the Civil Code provides that when the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. In computing a period, the first day shall be excluded and the last day included. Now let's compare this provision with Section 31, Chapter 8 of Book 1 of the Administrative Code of the Philippines. Section 31 tells us that legal periods, year shall be understood to be 12 calendar months, month of 30 days, unless it refers to a specific calendar month, in which case it shall be computed according to the number of days the specific month contains. Day to a day of 24 hours and night from sunset to sunrise. What we have here is a clear conflict between the two laws. Under the Civil Code, a year is composed of 365 days. Under the Administrative Code, a year is considered to be 12 calendar months. Which of the two laws should govern? In Commissioner of Internal Revenue versus Prime Town Property Group Incorporated, the Supreme Court teaches us that there is an implied repeal of Article 13 of the Civil Code. This is because Section 27 of Book 7 of the Administrative Code contains a repealing clause. Recalling our previous lesson, ang express repeal is the abrogation of a specified and particular provision of the law. An implied repeal is the repeal of another law covering the same subject matter, and the old law is in clear conflict with the new law. There is an implied repeal in this case because Article 13 and Section 31 of Book 1 of the Administrative Code covers the same subject matter, the legal definition of 1 year. They are in clear conflict with one another because the Civil Code definition limits a year to be 365 days. Under the definition of the Administrative Code, sinasama sa definition na ang isang taon na hindi lamang 365 days. Maaari itong maging 366 kung sakaling leap year. Pero dahil hindi naman sinabi ng Administrative Code na we hereby repeal Article 13 of the Civil Code, what we have here is an implied repeal. Hindi specific, walang label, at dahil daw GCQ na next week, either gawan mo na ng label yan, kapatid, o huwag ka na lang kamong umasa sa iyong ECQ fling. The case of Commissioner versus Prime Town Property Group is a case that is taken up in persons, in taxation, in remedial law, and again in statutory construction. Bihira akong magsabi, kapatid, but this is mandatory reading. This will be asked in the quiz later. Now let's look at the rest of the rules in computing legal periods. A year is composed of 12 calendar months. That is the rule from the Administrative Code. A month is understood to be 30 days. Again, wala pang mahirap dito, kapatid. The exception is when the name of the month is specified. Kung specific at may label ang buwan, then we count the number of days of the specific month. January has 31 days. May has 31 days. If the problem mentions a specific month, bilangan mo na, kapatid. Halimbawa, X hereby promises to pay 10,000 pesos to you 1 month from the date of the note. When will X pay? X will pay 30 days from the date of the note. Walang mahirap dyan, kapatid. Halimbawa naman, X hereby promises to pay 10,000 pesos to you 2 calendar months from today. If today is May 30, when will X pay? Article 13 teaches us that we exclude the first day and include the last day. We start counting not from May 30 but from May 31. Kung pagsasamahin natin ang dalawang calendar months gamit ang computation na itinuro ng Supreme Court sa kaso ng Prime Town Property, then X must pay 10,000 pesos on July 29, still for a total of 60 days. When the law speaks of days, it refers to 24 hours. A night is defined as the period of time from sunset to sunrise. Mahalaga ang definition ng day dahil ginagamit ito sa labor code. Under our labor law, a person must only be suffered to work for 8 hours each day, meaning 8 oras lang ang trabaho sa loob ng bawat 24 oras. Lampas sa 8 oras ay dapat bayad na siya ng overtime pay. Ang night naman ay mahalaga, lalo na sa criminal law. Under the revised penal code, if a person commits a crime at night using the cover of darkness para maikubli ang kanyang pagkatao o masikret ang kanyang karumal-dumal na krimen, that is an aggravating circumstance and it imposes a greater punishment. Nighttime determines whether the commission of the crime happened within what the law considers as night. Alam ko kapatid na isa sa mga dahilan na pinasok mo ang pag-aabogado dahil balita mo ay walang math dito. Well, fake news yan dahil merong math sa law school. Kokonti nga lang. Kasama ang computation ng period sa kokonting math na yan. Here are some tips and tricks that have helped me throughout the years. The easiest way to compute for period, subtract 1 from the date and that will be your final date. Adjust ka na lang kapatid kung ilang buwan ang pinag-uusapan. Second, whenever you see dates in the problems, pay attention. Maraming facts na binabato ang examiner pero bihirang-bihira na paglaruan niya ang date. When a date appears on the problem, rest assured that the date is relevant to your final answer. Third, be very careful of years that are divisible by 4. Kung divisible yan by 4, asahan mo kapatid na leap year yan. Kung damay ang February at divisible by 4, tandaan mo na may February 29 kapag leap year. Maraming professor ang pakiramdam nila ay ang talino nila kung ikalilito natin ang leap year. Don't ask me why I know, just remember this for now. To summarize tonight's lesson, number 1, customs are classified as social and juridical customs. Only juridical customs can be used to supplement the law. However, they must first be proven as facts. 2, a good custom, no matter its intentions, can never prevail over a specific provision of the law. 3, Article 13 has been impliedly repealed by Section 31 of Chapter 8 of Book 1 of the Administrative Code. A year is now defined as 12 calendar months. 4, dates appearing on problems are always important in relation to our final answers. I think we can stop here kapatid. I do have a few announcements to make before we end. First of all, thank you kapatid for your continuous support of this ongoing series on persons. I know I call it persons but we are actually covering as many aspects of the law outside the scope of persons. Second, the next lesson is going to cover the conflict of laws, provisions of the civil code. This is a 2 or 3 unit subject in law school. It's a minor subject kapatid and maybe comes up around 3 to 8% of the bar exam on civil code. The discussion is about to become more and more technical but I promise to share it with you in the simplest possible form. Madaming bumagsak sa klase namin sa conflicts kapatid at ayoko na matulad ka sa kanila. Hayaan mong tulungan kita. That being said, we will ramp up the difficulty of our quizzes. When a case is mentioned in the lesson, asahan mo na matatanong na yan. When you're asked to fill in the blanks only. No extra words needed. Starting next quiz, I will be asking questions covered in previous lessons. Law school kapatid is a function of stock knowledge. By the time you reach your 4th or final year in law school, wala ka nang babasahing bago. Lahat yan nadaanan mo na o linampasan mo lang o pinahapyawan mo at ngayon ay limot mo na. I am going to ask you about the same topics covered in previous lessons to reinforce your memory. As we continue with this series, we will cover more articles per episode or we will do longer videos. Honestly kapatid, hetong bahagi na ito ng persons ay hindi pinag-uusapan sa klase. Ina-assume na lang ng mga professors natin na ito ay hindi mahalaga o dapat maintindihan mo na ito mag-isa. If you agree with the direction I'm taking this series and you would like to continue, just type yes in the comments down below. Please post your scores or send me a private message if you have questions. Please do not discuss the questions so as not to spoil the quiz for those who will watch later. Third announcement, at ito kapatid ay aking pakiusap lamang. As I've mentioned in our previous videos, I have been selected as one of the Philippine ambassadors for the YouTube Creators for Change program. My project is ready. It's actually a game. And I hope you can play it. I will leave links to social media down in the description below so you can follow when the game comes out. Overtime na tayo kapatid. Thank you so much for watching. Like and share this video for good law school karma and I will see you 2 times next week.